All right, we're back on the record in the 53rd Circuit Court for the County of Sheboygan. We're calling the case next of People versus Amanda Panicali, file 20-5975FH. We have Ms. Panicali appearing by Zoom video. Her attorney, Mr. Gilbert's in the courtroom, as is the prosecuting attorney, Ms. Goodrich. We're here today for a docket call and also a bond violation hearing on a pending OWI charge down in district court and a show cause for some missed tests. We are providing public access both here and in the courtroom. And Ms. Panicali, I guess first I'll advise you that I did speak with the prosecutor and the defense attorney with regard to the testing issue. And based upon information I was provided that you are testing, I'm going to dismiss that show cause at this time.
Thank you, Your Honor.
All right, so Mr. Gilbert, we're here for docket call.
Yes, we are, Your Honor, and I spoke with the prosecutor, and we've come up with a new plea agreement. I've also discussed this matter with Ms. Panicali, and she wishes to accept this plea at this time, if I may approach.
You may.
I also provided her I signed a copy for her, but she has been provided with a copy of her advice of rights.
Okay. And Ms. Panicali, do you wish to enter a plea according to the terms of this agreement?
Yes, I do.
Would you please raise your right hand?
My bad.
Fine. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can put your hand down. Would you state your name for the record, please?
Amanda Renee Panicali.
Ms. Panicali, a guilty plea hearing is an important event because it includes you waiving important constitutional rights that you have. So listen very carefully. At any time, if you need to speak with your attorney some more, you just ask us and we'll make that happen. Do you understand that?
I do. Thank you.
All right, now you're offering to plead guilty to count 1, which is a charge of
You're bringing an amended, Your Honor, to remove the drug double.
Is count 1, unless I'm missing an amended information, it looks like was a conspiracy to deliver?
Yes, please, Judge.
That's would be an amended count 1. Remember, that wasn't an offense. It is.
Okay, do we have an amended coming or?
Ms. Patel's working on it.
Okay, all right. And so, Mr. Gilbert, do you consent to the filing of an amended information changing count 1 from a conspiracy to a delivery?
Yes, Your Honor, that was the agreement. Thank you.
Okay. All right, so Ms. Panicali, you're offering to plead guilty to a charge in an amended information to be filed today to a charge of delivery of the controlled substance Suboxone or buprenorphine. That is a felony crime. It's punishable by up to 7 years in prison and or what's the fine on that? Because on the information I have, it's the conspiracy fine. Right. All right, maybe we should pass this case. All right, Ms. Panicali, I'm gonna have to place you back in the waiting room while we get the paperwork straightened out because I don't have any information that has the proper charges on it.
All righty.
All right.
Okay.
Oops. so let's call the cases of the State of Michigan versus Robert Boyd. It's two file numbers, 20-5979FH and 5980FH. We have Mr. Boyd present in the courtroom, as well as his attorney, Mr. Gilbert, and the prosecuting attorney, Ms. Goodrich. We're providing public access both in the courtroom and online. And Mr. Boyd, good afternoon and welcome to the courtroom. We're glad to bring you here in person.
Thank you, Your Honor.
All right, and we're here today, Mr. Gilbert, looks like on a docket call on both matters and also a bond violation hearing. And it looks like the, maybe we could address the bond violation hearing first. It's alleged that that he violated the conditions of bond by engaging in assaultive behavior toward somebody in the jail. I guess before we would proceed with any evidentiary hearing on that, I would entertain preliminary arguments from the attorneys about whether that's whether I could violate his bond for that since he's not posted bond. Ms. Goodrich?
And I know that we have had a similar argument before. They are put on the list of bond conditions at time of arraignment. And that includes not having new crimes as a deterrent, even when in jail, to not acquire new crimes. And I would say that that still applies while incarcerated.
Okay, thank you. Mr. Gilbert?
Your Honor, in regards to that argument, that is exactly our argument. Mr. Boyd does not have a bond. That's the reason he's standing next to me today. He very much wishes he did have a bond, but he doesn't. And thus, when conditions are placed on, called bond conditions, he has to abide by those if he posts a bond. So our argument is he never posted bond, so he cannot have a bond violation based off of any activity that he would have that violated those conditions because he didn't do it. Furthermore, the prosecution has a misdemeanor charge going against him. That's a punishment enough for that activity that did take place, regardless of the bond violation. Furthermore, since this has happened, my client has been incarcerated the whole time. I think he has the record now for being incarcerated in the Sheboygan County Jail the longest of any individual, based off of because of the issues with COVID. I believe the penalty of 93 days is long past gone. That he has already served that since this incident took place. But back to the original argument, our argument is that you can't have a bond violation if you don't have a bond. Thank you, Your Honor.
Well, and this has come up from time to time, mostly in the context of a violation of a no contact order. And I do believe that we had previously held Mr. Boyd in violation of that very thing, of contacting one of the complaining witnesses. And there are no published Court of Appeals cases or statutes or court rules that I'm aware of addressing that. There are some unpublished Court of Appeals decisions that I've relied on to enforce no contact provisions. So it's a little bit of a gray area, but I'm going to only enforce that with regard to no contact provisions because that's intended to protect a specific person. I think it would be a little too broad to hold a defendant liable for contempt for violating all the conditions of bond when they haven't posted the bond. And there's conditions, all the standard conditions that are usually with those. I understand the prosecutor's concern about, having a disincentive for criminal cases in the jail. And I think that's taken care of by existing statutes. As I understand the law, if Mr. Boyd were found to be guilty of having committed a crime while in the jail, that would be a mandatory consecutive sentence. So if he's let's say he's found guilty in the district court and the district judge gives him 93 days in jail, he doesn't have any credit for that yet because it's mandatory consecutive. Whereas I've got him in jail on no bond in one of the cases. Bond has been revoked. I've denied his repeated motions to release him on bond. So practically, there's not a lot I can do anyway, and I think that would stretch the stretch the situation too far. So I'll find, I guess I'll grant what I expect is the defense motion to dismiss the show cause. I would grant that and dismiss that show cause in both files.
Thank you, Your Honor.
Thank you.
All right, and in terms of the docket call, Mr. Gilbert, are these cases ready to proceed for trial?
They are, Your Honor. We'd like a date.
All right, and we had previously discussed that we would go with file 5980 first. And how many days do you think you would need, including jury selection? Would 3 days suffice?
Your Honor, I believe that would be appropriate. When we first gave the number of days, I believe we were taking into consideration the COVID lockdown, and that we would have to move jurors in and out of the room and from downstairs, and that would just take up a considerable amount of time. In this case, I think 3 days would be sufficient.
Ms. Goodrich?
I would agree.
Okay. All right, Mr. Boyd, we are, we had the green light from the state to schedule jury trials now. And so we are giving dates. And so I'm going to give you some trial dates right now that are going to be firm dates. These are the dates we're going to go.
Okay.
People can subpoena all their witnesses and we're going to go on those dates. Because we have to find a 3-day chunk of time, it takes a little bit longer to find that many days in a row. So you're not going to love when it is. It's going to be Wednesday, October 6th, and Thursday the 7th, and Friday the 8th. So that's the soonest, looking at the calendar, that I can give you 3 contiguous days that aren't already claimed. But those will be your days. We're not going to schedule it. It'll happen those days. Okay.
Yes, Your Honor.
So we'll schedule jury selection and trial for Wednesday, October 6th through Friday the 8th. No adjournments will be granted except on good cause. Have trial witness and exhibit lists already been exchanged?
Your Honor, my exhibit list, it's only one additional name other than my client, and that will be to the prosecutor's desk.
Well, I'll give you, I mean, the trial's in 3 months, is the soon, almost 3 months. So I'll give you 14 days to file final witness and exhibit lists.
Thank you, Your Honor.
And I'm going to say jury instructions will be due. It looks like you and I, Mr. Gilbert, are in the Pettit trial the week before. So just so that,
Your Honor, the trial's no longer mine.
oh, that's right. That's right. Okay, well, I'm going to be in. So I'm going to order that proposed jury instructions would be submitted by Friday, September 24th. Are there any additional pretrial motions that the parties anticipate or no?
I don't believe so, Your Honor.
Not this time.
Okay. So there's no need to set for a docket call?
No, Your Honor.
All right, so we're going to schedule this in file 5980 for a jury selection and trial beginning Wednesday, October 6th. And in file 5979, I'll continue a docket call to October 6th. We'll just so there's something in the calendar at October 6th at 9 a.m. That's just so that the cases can track together. And the jury selection will begin at 9 a.m. We'll summon the jurors to report here for 8:30. And Mr. Gilbert, you'll ensure that Mr. Boyd has street clothes.
Absolutely.
Your Honor, did you say 5979 or 5980?
5980 is the one that's going.
Okay,
That's the one with the
okay.
felony firearm charge and. All right, anything further, Mr. Gilbert?
No, Your Honor, thank you very much.
Ms. Goodrich?
Yeah, thank you.
Okay, Mr. Boyd, I'm sorry I can't give you sooner dates, but at least I can give you dates.
Yes, Your Honor.
Okay, have a good day. We're gonna go off the record for a minute.
Your Honor, just to give you a heads up, Mr. Hallis, I know he called the court, he called me last night, told me, even though he's supposed to be here in person for his sentencing, he does not have a ride. He was panicking about it. I told him to at least zoom in and address it with you. What's happening. Thank you.
You're all set back there.
Okay. Thanks. All right, Ms. Panicali, can you hear us again?
Yes, I can.
Okay, oh, I'm sorry, do we have the amended information?
Yes.
Right there, Judge.
Oh, okay. All right, so Ms. Panicali, let's go ahead and start this over. You're still under oath, and you're offering to plead guilty to a charge in an amended information, which we have now accepted for filing, to a charge of delivery of buprenorphine. That is a felony crime punishable by 7 years in prison and/or $10,000 fine. And unless you're sentenced to more than a year in prison, there are mandatory sanctions on your driver's license. Do you understand the maximum penalty that you could face?
Yes, Your Honor.
All right. And are you on probation or parole anywhere?
No,
At the
I'm
time
just
that
on bond.
this, okay. At the time that this offense took place in September of 2019, were you on bond for any felony crimes at that time?
No, sir.
All right. Do you understand if you plead guilty, you won't have a trial and you're giving up your trial rights?
Yes, I do.
All right. And did you read and understand the rights listed on the advice of rights form?
Yes.
Did you give Mr. Gilbert your permission to sign the form on your behalf?
Yes, I did, sir.
You understand by pleading guilty, you're giving up all the rights listed on that form?
I do.
And is that what you wish to do?
I do.
If I accept your plea, you're giving up any claim that the plea was caused by promises or threats that no one places on the record today. Do you understand that?
Yes, Your Honor.
And you're also giving up any claim that it was not your own free choice to enter the plea. Do you understand that?
Yes, Your Honor.
And by pleading guilty, you're giving up your right to appeal. And if you wanted to appeal, you have to get permission by filing an application for leave to appeal. Do you understand that?
I do.
Also, your guilty plea waives certain issues on appeal entirely, and you can't raise them even if the Court of Appeals takes your case. Do you understand that?
I do.
There's a plea agreement in this matter that provides an exchange for your plea to count one. The prosecutor will dismiss the remaining charges and enhancements. There's restitution agreed upon of $40, and there's a sentence agreement for no immediate jail. Do you understand the terms of that plea agreement?
I do.
Mr. Gilbert, is that a full, fair, and accurate statement of its terms?
It is, Your Honor. Thank you.
Ms. Goodrich?
Yes, Your Honor.
And Ms. Panicali, do you understand that that sentence agreement is not binding on me? So at sentencing, if I wanted to give you jail, I wouldn't be bound by that sentence agreement. But if I wanted to give you jail, you would be allowed to withdraw your plea. Do you understand that?
I do understand that.
There's an important exception to that rule. If you engaged in misconduct between now and the sentencing, violation of bond or absconding or new criminal offenses, I wouldn't have to follow that sentence agreement, but you would have forfeited your right to withdraw the plea by your misconduct. Do you understand that?
I absolutely do.
All right. Other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No, sir.
Has anybody threatened you to get you to plead?
No, sir.
Is it your own free choice to plead guilty?
Yes, sir.
Knowing all this, how do you wish to plead to the charge of delivery of buprenorphine?
Guilty.
You want to tell me what happened back on September 10th of 2019 to make you believe you're guilty of that crime?
Yeah. An acquaintance of mine and my ex-boyfriend at the time, the father to my kids, reached out and asked for one of our Suboxone tablets, and which we agreed to, and he came over with $40 asking for one, and we gave it to him. I was fully aware of what was going on, so that's why I feel I'm guilty of it.
Okay. And did that happen in Sheboygan County?
It did.
All right. Counsel, are you satisfied with the factual basis?
I am, Your Honor. Thank you.
Ms. Goodrich?
Yes, Your Honor.
And Mr. Gilbert, are you aware of any other promises, threats, or inducements?
I am not, Your Honor. Thank
Ms.
you.
Goodrich?
No, Your Honor.
And Mr. Gilbert, your judgment as the court fully complied with the court rule?
The court has.
Ms. Goodrich?
Yes, Your Honor.
Ms. Panicali, we've given you a lot of information. It's possible that may have caused you to change your mind. So I ask you once more, how do you wish to plead to the charge of delivery of buprenorphine?
Guilty, Your Honor.
Well, I find that your plea is knowingly, understandingly, and voluntarily made, that there's sufficient basis in fact and law to believe you're guilty of that crime. So I hereby accept your plea. We'll have to schedule a sentencing date, and you'll have to meet with probation for an updated pre-sentence report. I guess, you know, part of what we're doing is making sure that you're doing well, you know, before we would decide on making sure there's no upfront jail. Any objection? Well, let's see. The August dates are awfully full right now. Any objection to setting schedule or setting sentencing for September 7th?
No objection, Your Honor.
Okay. Any objection, Ms. Goodrich?
No objection.
All right, Ms. Panicali, here's what I'm going to do. I'm going to schedule your sentencing for September 7th at 2:10 in the afternoon. That'll be in person here in the courtroom. And if you continue to do well, I've been told that you are doing well, then on that date, as I sit here today, it's going to be my intention to follow that plea agreement, but it's going to depend on you continuing to do well between now and then, okay?
Absolutely. I fully
All
understand
right.
that.
We do still have the matter of a pending show cause for the misdemeanor file that was filed while this case was pending. This case has been pending a long time. Any objection, Ms. Goodrich, if we were to allow that to be handled exclusively by the district court and dismiss that show cause?
No objection to that, Your Honor.
Mr. Gilbert, I presume no objection.
Your Honor.
All right, so Ms. Panicali, we also had a show cause pending for the misdemeanor case you had. I'm going to dismiss that show cause in this court and just let the district court deal with you on the misdemeanor charges that you have. And also now all that's pending up in front of me is a sentencing on this delivery from 2019. So if you stay on a good track between now and September 7th, I think the sentencing will go just fine for you, okay?
Okay, do I still have the show cause to deal with down in district?
Whatever you had down in district, you still have. I have no authority to
Okay.
deal with, okay?
Okay, thank you, Your Honor.
Okay, have a good day. So here's the plea agreement docket call and then the information. All right. We've got Ms. Rules. All right, we're next up in People of the State of Michigan versus Antoinette Sewells, file 21-6126FH. We have Ms. Sewells present by Zoom video. Her attorney, Mr. Gilbert's in the courtroom, as is the prosecuting attorney. We're providing public access in the courtroom and online. And we're here today for a docket call and a bond violation hearing. The hearing was for a positive THC test back on May 1st. I'll advise counsel, court staff gave me the updated testing. It looks like Ms. Sewells has been testing and has been testing clean since that time. So Ms. Goodrich, any objection to the court dismissing that show cause?
No objection.
Mr. Gilbert, I presume no objection.
Yeah, you presume right.
Okay.
Correct, Your Honor. Thank
All
you.
right, so Ms. Sewells, because you are testing and, I don't have any information that you are using, we're going to go ahead and dismiss the pending show cause, okay?
All
Just
right.
keep testing and keep complying with the bond conditions. All right. So Mr. Gilbert, we're here for the docket call. Do you know?
Yes, Your Honor, this matter appears that it is going to go to trial. However, my client has requested to waive her right to a jury trial and would like a bench trial.
Okay. Do the people consent to a bench trial in this matter?
Yes, Your Honor.
All right, Ms. Sewells, I have to just ask you some questions just to make sure you understand the rights that you're waiving. So I'm going to place you under oath. I'm not going to ask you about the case right now, but I'm going to ask you to raise your right hand. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you can put your hand down. Would you state your name for the record?
Antoinette Marie Sewells.
All right, Ms. Sewells, do you understand that the United States and the Michigan constitutions give you the right to have a trial by a jury?
Yes.
Have you had a chance to consult with Mr. Gilbert about the pros and cons of exercising that right to a jury trial or waiving it and trying the case to the judge?
Yes, I have.
And are you voluntarily giving up your right to a jury trial?
Yes.
Do you choose to be tried by the court?
Yes.
Do you understand that then I will hear testimony at the trial from the witnesses and I'll make a determination as to whether the prosecutors proved your guilt beyond a reasonable doubt and not a jury?
Yes.
Do you understand that?
Yes, sir.
Has anybody promised you anything to get you to waive your right to a jury trial?
No.
Has anybody threatened you to get you to waive your right to a jury trial?
No.
Is it your own free choice to waive the jury trial right?
Yes.
All right, and we have obtained the prosecutor's consent to a bench trial. Looks like Ms. Sewells has previously been arraigned on the felony information and consulted with her attorney about that. I find that my previous involvement in this case has been limited to procedural matters and dealing with the bond violations, which have been unrelated to the underlying substantive offense. So I don't find that there's any basis for me to be recused from acting as the finder of fact. I find that the defendant has been properly advised of her right to a jury trial. She's had an opportunity to consult with counsel. I have obtained a waiver in open court as required by law. I do find that the waiver has been made knowingly, voluntarily, and intelligently. And therefore, I accept Ms. Sewell's waiver and the prosecuting attorney's waiver of the right to a jury trial in this matter. And we'll schedule this then for a bench trial. What's the estimated length of time?
I believe 1 day, Your Honor.
1 day.
Okay. How long do you need to exchange witness and exhibit lists?
14 days, Your Honor.
That'd be fine.
Let me just check something in the court docket. And would this trial would be scheduled in person? Are there any witnesses that the parties would request to testify over Zoom, or would they be testifying in person?
I would like her to be in person, Your Honor.
Okay. Ms. Goodrich?
I believe in person. This was the first I heard of the bench trial, so.
Oh, okay.
Witnesses.
Okay, well, if you have any motions, you can file them. All right.
And I did not mean to spray this on you. Sorry. We discussed it this morning.
I could give you Thursday, September 2nd for a bench trial. Would that work, Mr. Gilbert?
Tuesday, Your Honor?
Thursday, September 2nd.
Usually that's district court day, but it's a trial, Your Honor, so I'll move those cases. So that'd be fine.
Ms. Goodrich, Thursday, September 2nd.
That'd be fine.
Okay. We'll begin at 9 a.m.
Yes.
All right, so Ms. Sewells, we're going to have your bench trial is what it's called, where we'll do the trial in front of me on Thursday, September 2nd, beginning at 9 a.m. And your attorney and the prosecutor will exchange witness and exhibit lists within 14 days of today's date. Okay, do you have any questions about that?
No, sir.
Okay, anything further, Mr. Gilbert?
No, Your Honor, thank you.
Ms. Goodrich?
No, thank you.
Okay, we'll see you then, Ms. Sewells.
Thank you.
All right. We have Ms. Wilhelm in the waiting room. She's scheduled for 3:20. Let's bring her in. It's a lot easier to find dates for a bench trial. We could really get through the backlog if people do that. All right. Connect your audio here. All right, we're next up in People of the State of Michigan versus Amanda Wilhelm, file 21-6127FH. We have Ms. Wilhelm present by Zoom video. Her attorney, Mr. Gilbert's in the courtroom, as is Mr. Goodrich, the prosecuting attorney. We're providing public access both in the courtroom and online. And Mr. Gilbert, we're here for docket call.
Yes, Your Honor, this is our first docket call in this case, and I have gone through, the prosecutors provided me with a plea. I presented that with my client. She'd like some additional time to contemplate that. We'd ask the court to schedule this for one more docket call, Your Honor. Hopefully it would be resolved at that time.
Okay. Looks like the August dates are filling up. Any objection to September 7th?
No, Your Honor, thank you.
Ms. Goodrich?
No objection.
All right, so we'll schedule the docket call then to be held, continued docket call September 7th at 2:20 in the afternoon to be held in person. All right, Ms. Wilhelm, we'll see you in the courtroom on that date and time, okay?
Thank you. And Mr. Gilbert, is it possible to get email or something with that as well? Just that date and time?
You'll get a notice.
Thank you.
Our office sends those out, yep.
Okay. And you'll get a written notice from the court too.
Okay.
And 3:30, we're Mr. Palace, and he is in the Zoom.
It's supposed to be in person.
Yes. Mr. Palace, can you hear me?
Yes, I can, sir.
All right, we're here on People versus Michael Palace, file 21-6084FH. Mr. Palace is appearing by Zoom. His attorney, Mr. Gilbert, is present in the courtroom, as is the prosecuting attorney, Ms. Goodrich. Agent Young from the Department of Corrections is present in person. Mr. Palace, why are you not in my courtroom? You were ordered to appear in person.
Your Honor, I thought I had everything worked out for both brides, and they both failed today. I am at the mercy of the court. I did everything I was supposed to do. I called my lawyer. I called the court to let them know my situation. I am shaking in my pants. I don't know what to say.
Mr. Palace, you seem bound and determined to make a case that's not very difficult, more difficult than it needs to be. Not just today. I'm talking about through the life of this case here, we had problems with you doing the pre-sentence report. I can arrange a ride for you, but you're not going to like my ride.
I understand, sir. I mean, I don't have many family up here. I had 2 rides and they had things that went happen. I apologize.
I mean, you don't even have a great connection. I can barely hear you. I'm not going to sentence you over Zoom. Mr. Pallas, the sentencing recommendation is for you not to go to jail today. You're going to make it hard for me to follow that recommendation if you don't cooperate with what's going on. You, sir, are going to be standing in my courtroom in person at 1 p.m. Or can you do 1 p.m.? I mean, I know you're on a 2 o'clock docket typically, but will 1 p.m. work on that day?
It should, Your Honor.
It'd be 2 weeks from today, the 27th.
That should be fine, Your Honor.
Mr. Pallas, you are going to be in my courtroom in person, 1 o'clock p.m., 2 weeks from today, July 27th. If you are not, I don't care if you're on Zoom, I will sign a warrant for your arrest. You understand that? You're ordered to be in person. Your appearance over Zoom does not satisfy that order and constitutes a non-appearance. You understand that?
I completely understand that, sir. I will be there on the 27th at 1 o'clock.
If you cannot make it, you contact Agent Young or your attorney. We can revoke your bond and have a police cruiser pick you up and bring you up by way of the Sheboygan County Jail. We can do that too. But come hell or high water, you're going to be standing in front of me in person 2 weeks from today at 1 p.m. or I'm signing a warrant for your arrest.
Yes, sir. I will be there at 1 o'clock on 27th.
Okay. I want you to write a letter apologizing to Agent Young because you've wasted his time. He's here today for sentencing as ordered.
Yes, sir.
Bring it with you. We'll see you then.
All right, I will. All right, thank you.
Hate to do this to you, Mr. Keough, but you ready to go next? Turn this down. All right, we'll call the case of People versus Brandon Beaugrand, file 21-6131FH. We have Mr. Beaugrand present in the courtroom with us today as is his attorney, Mr. Keough, and the prosecuting attorney, Ms. Goodrich. We're providing public access both online and in the courtroom. And Mr. Beaugrand was scheduled this morning, but had some difficulties appearing. I am aware that he was trying to, or he was communicating with his lawyer, so we did pass the case to be called this afternoon in person, and so he is here, so there's no harm, no foul for that, Mr.
Very good, thank you, Judge.
We're here for docket calls. Do you know how we're proceeding?
We do have a potential plea, Your Honor. I do have a signed advice of rights form by my client, and he gave me permission to sign the plea agreement. And that should address the plea agreement to resolve this matter. Ms. Goodrich was given a copy of the plea agreement as well.
Do we have an amended information amending the habitual yet or no?
No, Your Honor.
Okay.
We're assisting you.
That's fine. Would you consent to the filing of an amended information changing the habitual from a fourth to a third?
Yes, Your Honor.
And Mr. Beaugrand, do you wish to enter a plea according to the terms of this agreement?
Yes, Your Honor.
Would you please raise your right hand? Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Okay, you put your hand down. And would you please state your name for the record?
Brandon Robert Beaugrand.
And Mr. Beaugrand, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So I want you to listen carefully. At any time, if you need some more time to talk to Mr. Keough, or you don't understand something that's going on, just say so. I don't want you to pass on that and just assume. If there's something going on you need to talk about, just let us know and we'll let that happen, okay?
Yes, Your Honor.
All right, now you're offering to plead guilty to count 2, which is a charge of unlawful posting of a message on the internet. I've not seen that charge. Let me read that charge, make sure I understand what it is. Okay. All right, and that is a felony crime. It's punishable by up to 2 years in prison and or a $5,000 fine. And the court can order you to reimburse the government for expenses incurred in relation to the violation, whatever those are. And as a habitual offender, 3rd, and that means that the penalty could be doubled in the court's discretion, so that as a habitual offender, 3rd, that would be punishable by up to 4 years or a $5,000 fine and reimbursement of government expenses. Do you
Yes, Your
understand?
Honor.
Okay, and do you understand the maximum penalty you could face?
I do, Your Honor.
Are you on probation or parole anywhere?
No, Your Honor.
Were you on bond for any other case at this time back in February of 2021?
No, Your Honor.
If I accept your plea, do you understand that you will not have a trial and you're giving up your trial rights?
Yes, Your Honor.
Did you read and understand the rights listed on the advice of rights form?
I did, Your Honor.
Do you understand that by pleading guilty, you're giving up those rights?
Yes, Your Honor.
It looks like that's an outdated form, so I'm going to go over with the trial rights that you have. You have the right to be tried by a jury, to be presumed innocent until proven guilty, and to have the prosecutor prove your guilt beyond a reasonable doubt before you can be convicted. Do you understand those rights?
Yes, Your Honor.
At the trial, you'd have the right to have the witnesses against you appear. You'd have the right to question those witnesses, and you'd have the right to have me order any witness to appear that you wanted to give testimony in your own defense. Do you understand those rights?
I understand that, Your Honor.
And at that trial, you'd have the right either to remain silent and not have the silence used against you in any way, or you'd have the right to testify in your own defense if you chose. Do you understand those rights?
Yes, Your Honor.
Do you understand by pleading guilty, you're giving up those rights?
Yes, Your Honor.
Is that what you're choosing to do today?
Yes, Your Honor.
If I accept your plea, you're also giving up any claim later on that it was caused by promises or threats that no one puts on the record today. Do you understand that?
Yes, Your Honor.
You're also giving up any claim that it was not your own free choice to enter it. Do you understand that?
Yes, Your Honor.
There are a couple of important limits on your appeal rights I want to make sure you understand. The first is that a guilty plea waives your right to appeal. And if you wanted to appeal, you'd have to get permission by filing an application for leave. Do you understand that?
Yes, Your Honor.
And secondly, the types of issues you raise on appeal are more limited. A guilty plea waives some issues entirely. Do you understand that?
Yes, Your Honor.
The plea agreement provides in exchange for your plea of guilty to count 2, habitual 3rd, the prosecutor will dismiss the remaining counts, dismiss the habitual 4th notice, and dismiss 2 pending files that are in the misdemeanor cases. They're pending in this county, Mr. Keough?
Yes, Your Honor.
Okay, the prosecutor is going to dismiss 2 misdemeanor cases pending in the 89th District Court. Do you understand the terms of that plea agreement?
I do, Your Honor.
Mr. Keough, is that a full, fair, and accurate statement of its terms?
Yes, it is.
Ms. Goodrich?
Yes, Your Honor.
Mr. Beaugrand, has anybody promised you anything beyond that plea agreement to get you to plead guilty?
No, Your Honor.
Has anybody threatened you to get you to plead?
No, Your Honor.
Whose choice is it to plead guilty today?
Mine, Your Honor.
And are you making that choice freely?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge of unlawful posting of a message, habitual 3rd?
Guilty, Your Honor.
Mr. Keough?
Thank you. Your name is Brandon Robert Bogrand, is that correct?
Correct.
Directing your attention back to February 21st, 2021, were you in Sheboygan County?
I was.
And are you familiar with an individual by the name of Loretta DeRocha?
I am.
And does she have a nephew by the name of Josh Guan or Josh Gwynn?
Josh Block, correct.
Okay, and did you have former business dealings with Josh at some point in your life?
I did.
And do you believe that back in February that Josh owed you money and it's stolen from you?
Correct.
Did you believe that you could perhaps get that money back and be made whole by making contact with Josh's, I guess that would be aunt?
I did.
And you sent her inappropriate messages, is that fair?
Yes.
Did you go on Facebook Messenger and send her essentially some threatening and offensive messages?
On social media, Facebook, yes.
On Facebook Messenger?
Yep.
And specifically, your goal was to try to cause her distress and get her to get the money that you thought she could get from Josh. Is that fair?
Correct.
And in fact, one of the messages you sent to her was, please pay me the money that Josh F'd me over on. He stole tools and everything. Is that correct?
Correct.
And is it also true that you made a statement also, I'd like to F your brains out for a tip?
Correct.
And you also said, I'll personally F your ass while gutting you?
Correct.
And then you asked if she was scared. Is that true?
Correct.
Do you believe that as a result of those messages that caused Loretta DeRocha to feel frightened?
Correct.
And she suffered emotional distress and felt terrorized as a result of those messages?
Yes.
And you indicated that this all took place in Sheboygan County. Is that true?
Correct.
Thank you. I believe that's a factual basis on count 2, Your Honor. And also, let me just get a couple of other things. Is it true that back in 2008, you have 2 felony convictions from the 53rd Circuit Court here in Sheboygan? One for conspiracy to commit breaking and entering with intent, and a second for breaking and entering with intent. Is that correct?
Correct.
And also in 2008, you also had a larceny of building conviction from this court. Is that true?
True.
I believe that's factual basis on HAP 3 and count 2, Your Honor.
Actually, I was just handed the amended information, and so it only lists a couple felony convictions, so I should probably make sure that we have the ones that are listed.
I can ask about that also. Mr. Beaugrand, is it true in 2009 you had a conviction for a delivery manufacturer of a controlled substance in this court?
I was charged for conspiracy of delivery and manufacturing.
Okay. Did you also have a conviction for larceny in a building from this court?
I was on a HIDA Act, and while doing so, I caught a charge, and that revoked my charge.
Okay, so that
became
became a conviction on your own?
Yeah, I was a minor, and I was sentenced to prison in this county.
Well, you were still in this court, is it
I
right?
turned
In this court?
18, yeah,
Okay.
while being sentenced to prison.
So you do have a conviction for larceny in a building from this court from
Correct.
2008, and you also have a controlled substance conviction from 2009 in this court as well?
Yep, and I sat my time for all that.
Thank you.
Ms. Goodrich, do you concur that the factual basis has been established?
Yes, Your Honor.
And Mr. Gilbert, are you aware of any other promises, threats, or inducements
Uh,
for the plea?
I am not aware of any other,
Promises, threats, or
no, I'm
inducements?
not aware of any.
Ms. Goodrich?
No, Your Honor.
And Mr. Keough, in your judgment, has the court fully complied with the requirements of the courtroom?
It has, Your Honor. Thank you.
Ms. Goodrich?
Yes, Your Honor.
Mr. Beaugrand, I've given you a lot of information today. It's possible that may have caused you to change your mind. It should be fine. I just want to ask you to make sure that this is your own free choice.
Yes, Your Honor.
So how do you wish to plead to the charge of unlawful posting of a message as a habitual offender third?
Still guilty, Your Honor.
All right, well, sir, I find that your plea is knowingly, understandingly, and voluntarily made, and that there's a sufficient reason, in fact, and law to believe you're guilty of that crime. Particularly, although getting into the details, was a little unsavory. I think that was important because as I was hearing it at first, I wanted to make sure that this was not just a civil violation of the, Fair Collection Practices Act or something. And I think the details of that establish in my mind that it does satisfy the statutory requirements. So I do find that there's a reason to believe that you're guilty of that crime. So I accept your plea, sir. We'll schedule sentencing for September 7th at 11 a.m. in person. And Ms. Goodrich, any objection to continuing bond until that time?
No objection.
Okay, so I'll continue your bond, sir. And we'll see you that day. And
Thank
you'll
you,
have
Your
to
Honor.
contact the probation department so that they can prepare a pre-sentence investigation report.
Yes, Your Honor. Upstairs, correct?
Yep,
I'll
just
take it
down.
down.
Okay.
You have any questions, sir?
No, Your Honor. Thank you for your time.
Okay, we'll see you then.
Thank you very much, Your Honor.
All right, and Mr. Gilbert, it looks like our final matter is People versus Stribic.
Yes, Your Honor.
It's 2 files, 21-6081 and 6116FH. They're scheduled for 3:40 PM. And do you know where Mr. Stribic is?
I do not, Your Honor. This really surprises me. I know our office did send him the notice, and it also notes that they called, telling me I'd be here in person. He has been in contact with me since our last hearing about the possible bond violations, and I tried to call him today, and I couldn't get through on the number.
Okay, I guess, I know it's been a long day, but it was only 11 minutes ago. I think what I'd prefer to do is take a 9-minute recess, and we'll give until 4 PM to appear before we address it.
Thank you very much, Your Honor.
All right, we're back on the record recalling the cases of People v. Joseph Stribick. It's set for a docket call and a bond violation hearing today. And Mr. Gilbert, any luck trying to track down Mr. Stribick?
No, Your Honor, again, I stated, this really surprises me. I have had contact with Mr. Stribick over the course of the last week, but I did try again while the court was generous enough to give an additional 9 minutes, and I got put into, there was no answer, got put into voicemail.
Okay, Ms. Goodrich, any requests?
Your Honor, I'd ask a bench warrant to be issued. Mr. Stribick was notified by the court last time he was in court 2 days ago.
All right, and this is scheduled for a show cause hearing. So I believe that even under the new criminal justice reform laws, the court can issue an immediate bench warrant, which I will do with no bond. We've got concerns whether Mr. Stribick is complying with the terms of his bond. I made it crystal clear to him that he was expected to be here. He's not here. I don't know what he's doing on bond, so there'll be a warrant for his arrest.
Thank you.
Thank you.
All right, and that'll be in both files. And that concludes our docket today.
Thank you, Your Honor.